we're very happy to have this really terrific panel with us today. I'm going to make some very brief introductions and just to frame some of the questions that we would like to discuss on this panel, and then give it to our experts here. We have with us Dr. Sarah Myers-West, who is the managing director of the AI Now Institute and the co-author of a really excellent report that just came out, I think, last week on the power of big tech. She also has a book coming up called Tracing Code, which examines the origins of commercial surveillance, and just coming off the heels of being an advisor at the FTC. Next to Sarah, we have Shaul Sussman, who is the Associate Director for Litigation Bureau of Competition at the Federal Trade Commission, and who I assume will be speaking in his personal capacity today. We're very excited to hear. And then next to me, I'm particularly happy to introduce Kevin Kouate-Fadoua, who is a student here at the law school, an ILJ scholar and a Furman scholar. And I remember convincing him that NYU is the right school for him to come. And I hope he's happy that he made that choice. But he's also done some terrific work with Kathy Sharkey. For those of you who have been in the beginning, will have heard, and has a really interesting take on AI and generative AI in particular. So this panel follows, I think, quite nicely the panel just before us. And I thought the last one of the last comments James made in response was, well, you know, a regulator might actually like having one big actor being in control of different components of the infrastructure that comprises AI, because then it's easier to regulate it, easier to ascribe liability. But of course, that comes with its own challenges. And in the report that I had just mentioned with Sarah and her colleagues at AI Now co-wrote, they, I think, take an issue with the power that's being amassed by the big tech. Some of it as a result of market acquisitions, but some of it as a result of obtaining over time control over relevant pieces of infrastructure that then engendered other powers to those companies to the exclusion of other market entrants. And that in a bit echoes a paper that Thomas Stryens and I wrote last year, Confronting Data Inequality, where we made basically an argument that controls over data generating and data transmission, data storage infrastructures create powers not just to determine who has access to data and on what terms, but also the power to determine what becomes data in the first place. And I think, as we heard from Stein about ways in which, you know, ChatGPT and other generative AI technologies are trained, which is that they're really trained on what is out there, the type of data that is available. Then these questions around, well, who decides what is datafied and what isn't, become important as well. And so while in the prior panels, we really try to focus on specific fields of law and challenges that those fields might have in regulating concerns associated with generative AI, in this panel, we want to focus more specifically on infrastructure. And as Benedict mentioned in the beginning, not just the technical dimension of it, but also the organizational and the social practices. And maybe ask the question, thinking about infrastructure, should we think about AI as an infrastructure? Thomas had asked in the prior panel, should we think of it as a service? Should we think of it as a product? Should we think of it as an infrastructure? Kevin has a different idea. He thinks we should think of it as a capability. And with that kind of framing, I think I want to open up the discussion also with an idea of thinking, what is different ways of thinking about AI tell us about what kind of market is out there, or what kind of market we might be creating, what are the distributions that this entails, not just nationally, but also globally. And maybe we'll start with Sarah first.
Sure. Thank you for having me. I think just to start with some broad framing, I'd like to start by unpacking how AI as we know it today really cannot exist without big tech firms. And I'll unpack that infrastructurally in a moment. But just to sort of orient ourselves, what that means is that necessarily meaningful reform will have to tackle concentration of corporate power and the ways that AI is particularly functioning to entrench the economic power of these firms. AI is being used to make decisions that can shape the trajectory of our lives, from the deeply impactful, what kinds of jobs we're able to get, how much we're paid, whether we can access decent healthcare and a good education, to the very mundane. What's the cost of the goods on the grocery shelf, or what's the route that we're sort of sent along as we go home? But across all of these many domains in which AI is being used to intermediate our lives as infrastructure, the same problems show themselves. Often this technology doesn't work as claimed, and it produces high rates of error that are not distributed evenly across us. They often exhibit unfair and discriminatory results that amplify existing patterns of inequality. But these visible problems are only the tip of the iceberg, and the opacity of this technology means we may not be informed when AI is in use, or how it's working. And this means that we have little to no say about its impact on our lives. So I'd like to go back to that first claim. Dependencies in AI bear out along the dimensions of tech firms' data advantage, their computational advantage, and their geopolitical advantage. I'll focus a little bit more on the first two, and the third I can unpack maybe if it comes up in the discussion, but I think is less relevant to this panel. So the data advantage. The firms that have access to the widest and deepest swath of behavioral data insights through surveillance will have an edge in the creation of consumer search products. Consumer AI products, forgive me. Big tech companies have embedded themselves as core infrastructure across many different kinds of disparate domains, and this means that they have a necessary advantage in the end tooling of products that are targeted to health, to consumer goods, to education, as well as in the generation of AI into product. The computational advantage. AI is fundamentally a data-driven enterprise. In its current flavor, we should remember that AI has meant many different things over the course of a nearly 80-year history, but the current of AI research over the past decade plus has really focused on AI at scale, at very data-driven data-driven visions of artificial intelligence. And this means it's very heavily reliant on substantial computing power to train and tune and deploy these models. This is tremendously expensive and runs up against material dependencies that even the largest companies are struggling with. I'm not entirely convinced that they yet know how to make these systems profitable. And given that they're going to be under extreme levels of pressure to figure out how to eke out money, even as they're moving swiftly to deploy AI to product to sort of seek out a first mover advantage. So what this means is that although AI startups abound, we're hearing lots of new names of companies emerging. They should be understood best as barnacles on the hull of big tech. They're licensing server infrastructure, and as a rule, they're competing with each other to eventually become acquired by big tech firms that have this ecosystem advantage. And lastly, AI systems and the companies that produce them are being recast not just as commercial products, but as strategic economic and security assets that need to be boosted by policy and never restrained. And this is a longstanding narrative that tends to conflate the dominance of big tech as synonymous with economic prowess, particularly in the US. And I think we've only recently seen a shift in sort of the orientation of industrial policy that begins to think of the geopolitical advantage of tech as, in different frames. I think that's reflected in the White House executive order on competition when it says, that we don't, necessarily want to see national monopolies. We want to see a competitive tech market, and that's much more in the national advantage. So just to tie all of that together before we can move on to the conversation, these three dimensions of advantage are why muscular competition and privacy enforcement is crucial to regulating AI. These give us a strong foundation to build from as we tackle this challenge. And it's key that we learn from the past decade of tech-enabled crises as we start to chart the path forward. Thank you.
Thank you very much, Sarah. Maybe we'll go to Kevin, because I think you pick up in your paper, which I hope is going to be published soon.
I hope so as well.
On some of the issues and dependencies, but maybe from a slightly different take.
Yeah, definitely. Thank you, Professor Fisher, for the introduction and for having me on this panel. I think this is a very timely topic and one that I've been quite passionate about and that I've dug into as a research project during my third year. And in my introductory remarks, I'd like to make 3 points. The prompt that we had today for this panel is asking whether generative AI will entrench infrastructural power and impair competition. And as a first point, I want to question the relationship between concentration of AI infrastructure on the one side and overall competitive effects on the other side. And my take on that is that the relationship is quite complicated. You could have concentrated infrastructure, but overall beneficial competitive effects. And that's why I think this topic is so complicated. The second point from there is that I think the best way to frame the potential infrastructure issues around generative AI and other types of AI is to understand them as an issue of access to powerful AI capabilities. And the third point going from there, if we frame those issues as access issues, it's unclear, at least to me, how we can guarantee access to powerful AI capabilities like generative AI using our current toolkit of policy and legal tools. So I think that's really a call for regulators and scholars to think outside the box and proactively think about these issues. So going back to my first point, I want to reflect on the prong that talks about entrenching infrastructure power and also impairing competition. I think to me, it's clear that there are risks of concentrated infrastructure. As Sarah mentioned, generative AI and other types of AI require lots of data, talent, and computing power that are getting even more expensive. So those are very high fixed costs and very hard to duplicate. So on the infrastructure side, there's clear trends toward concentration. But at the same time, I think that whether that concentration of infrastructure harms competition, this if we define competition more broadly, is much less clear. And I think for two reasons, one that is specific to AI and one that is more general to regulating new technologies. On the first reason, AI, the reason why it concentrates is that it's also that AI inherently favors concentration. The more data you have, the more talents you have, the more computing power you have, the better AI you can build. So I think there's a bit of a tension where by having more concentration in these capabilities, the firms may build better AI that then many other industries can use to compete better in these other industries. So we're seeing right now, many industries across the board adopting ChatGPT to become more productive, potentially more innovative, reducing costs and maybe reducing prices. So more competition in their own industries. So I think that's what makes our topic so complicated, is that concentration of infrastructure can have these potentially huge benefits for competition. And the second point that is more general as to why concentration doesn't mean harm to competition necessarily is that in theory, we can regulate this concentrated infrastructure. That's something that we've done with electricity. That's something that we've done with telecommunication networks for a while. And it has been proposed for AI as well. Last year, Professor Tejas Nareshanya from Berkeley wrote an article called Machine Learning as Natural Monopolies, where he suggests using this model of utility regulation, where we have one concentrated infrastructure company, but we then open access to everybody else in the industry. And I'll mention later, I'm not convinced that this is the right model. That's one that's been advanced. And segueing to my second point, I think that the key question is for our topic is whether economic actors outside of big tech will have broad and fair access to AI capabilities. And here, if it's hard to access, the incumbents, let's say big tech, controlling the infrastructure, then can threaten to foreclose AI capabilities. If you don't do what I want, I will prevent you from getting access to that AI capability that you want. And in that way, they could exercise market power, and then you get anti-competitive types of effects. And that's where concentration can become very harmful. But to start with a framework to think about access, I think that there are multiple ways that we could get to that level of broad access. And one way that we could at least hope for could be a private market solution. I think the big tech companies will say that the private market will solve the issue. I'm personally not convinced, but what's interesting with this moment in AI, I think, is that it's actually quite unclear whether we'll get that broad access through the private markets or whether we will not. Because on the one side, there are some signs that we may get democratization in AI capabilities. You have more and more startups that get lots of fundings from VCs and that are entering the space. You have a proliferation of open source or open access type of tools, or open source or free models that you can get on platforms such as Hugging Face, which is a repository for open source models. And for open access, you can think about the ChatGPT API, for example, where you need to pay, but anybody can pay and subscribe and then get access to this type of AI capabilities. But on the other side, I think that there are very powerful signs that we may not get to broad access through just the private markets, because it's getting, as Sarah mentioned, it's getting more and more expensive to build these models in the first place. And if you look at the startups that are being funded right now, a lot of them are not AI infrastructure startups. They are AI application startups. So they actually use the infrastructure from OpenAI or Google and just build applications on top of them. So you don't get more variety of companies able to build the foundational and infrastructural models. And as a second kind of force that hinders broader access without regulatory intervention, at least, as the recent AI Now report illustrated, there's been a continuing aggressive campaign by big tech to invest, influence the new startups, and potentially down the line that could lead to acquisition. And overall, the ecosystem remains very dependent on big tech as a whole. And so that's, I think, a good segue to the second way we could guarantee broader access, and that could be doing merger review. So we could say there's a concern of concentration, so we will try to block mergers where, let's say, Google tries to acquire Anthropic AI, let's say. Now we will try to find or assess whether there are some anti-competitive concerns there and maybe block that merger. And a third regulatory modality to guarantee access that I think is actually more intuitive than merger review would be this idea of utility regulation that Professor Nareshania has argued for, or you could call it also infrastructure regulation, where you say it's okay to have a few incumbents control the infrastructure. We'll just regulate on top of that and make sure that they open that infrastructure and that everybody can access it in a fair way. And I think it's more intuitive because of that trend of AI to concentrate and to favor concentration and scale. And the third point to conclude on my side is that I think that both these models, utility regulation or merger review, would actually be challenging to implement as interventions under current doctrine or with current regulatory tools. Or if you look at utility regulation in the first place, which again, I think it's a bit more intuitive, that model worked pretty well, relatively well, for electricity and telecommunications. But the big difference is that those infrastructure were really commoditized type of infrastructure. So everybody can plug into a network, let's say an electricity network, and get electricity in a very standardized way. Everybody can more or less plug into a communication network and send messages through it in a pretty standardized way. But when you think about AI, I think one key difference is that in many cases, you cannot just plug into AI. AI is more of a capabilities that you need to really customize for every use case. Sometimes you need to retrain it. Sometimes you even need to re-architect it. It can be a very involved type of project. And so it's going to be much more challenging for a regulator to impose requirements, especially ex ante on it, because you need to account for this variety of customized use cases. And I think one thing that's dangerous today when you look at ChatGPT is that it gives us this impression that now we have this one AI model that can do anything, and you just add ChatGPT to solve all of your problems. But I think that this will only be true to some extent and only for very or relatively generic type of task. If you think of what ChatGPT does, it's generic language tasks. It can rephrase things in a very compelling way, but it's just one type of task. But there are many more use cases that may require more customization. If you look at autonomous vehicles, the industry has been struggling to fine-tune their models for decades, still not working. The thing that type of AI that I'm more specifically looking at is what I call innovative AI, or use AI to try to discover new scientific breakthrough, like discover new drugs, discover new materials. there I think that customization will be much more necessary even after ChatGPT. And for a regulator, it would be very hard to understand how much AI this centralized infrastructure has to share with others. Very hard to define that. So as a fallback, just to conclude here, we may fall back to merger review, but I think there are a lot of challenges there as well, where merger review usually looks at specific product markets. But here with AI-enabled companies, you often have different products that are being implemented. It's not necessarily the same product, it's using the same capabilities, but the product markets may be very different, and merger review may struggle to capture that a little bit. So if you think of OpenAI versus Google, OpenAI doesn't really compete with Google, at least it didn't compete before this licensing agreement with Microsoft, because OpenAI is not about search engine, it's about other types of AI capabilities. But we may still be concerned about Google or Microsoft, let's say, acquiring OpenAI at the capabilities level. So I think that that's one way I've been thinking about AI, less as infrastructure, because again, it's less commoditized. It's not one infrastructure that somebody can just plug into, but more capabilities where a firm that has this capability can customize their AI for different use cases. And I think that's a bit hard to regulate, and we need to practically think about how to do that.
Great. I think one thing that's become clear throughout this whole day, which probably was clear even before this event, is that one of the difficulties in talking about AI as a category is that it captures so many different functionalities and different technologies. And so one could, depending on how one talks about AI, one could think about regulatory, both problems and regulatory solutions differently. But maybe in turning to Shaul for his reflections, so this idea of, on the one hand, there's a kind of potentially concentration of control over relevant infrastructures. Maybe we could tease out more in terms of what infrastructures are actually really relevant for generative AI, where control over those is going to become really key. And that's the kind of concentration that we should be worried about. And maybe that also goes to the challenges of defining concentrations in the market. And then similarly, if we take Kevin's approach, talk about capabilities, what's really important here? In the data space before generative AI, we might have thought, well, if you have a platform, if it's a big platform, a social media platform, e-commerce platform, you have tools by which you define what data is generated, then you sort of gate it off, and that gives you competitive advantage for purposes of data analytics. Is there something new now here, given kind of how Stein described the training for something like ChatGPT, where there's a lot of transfer knowledge? And, is it really the computing power that's now the most important thing? And that's where we kind of worry about concentration. And if so, should we be looking at, private equity companies that, fund renewable sector or the control renewable sector, because, their terms and conditions are going to affect who is going to be able to acquire computing powers on what terms. So I'm throwing a lot at you, but I'm hoping we could continue talking about after your initial intervention.
Sure, and I'll maybe try to talk about three separate vectors through three concrete examples from the last 15 years or so, and hopefully that can set up the discussion. So three aspects that I think are worth keeping in mind when we talk about AI kind of come from three lessons or three specific cases from the last 2 decades. And I'll touch upon each of them and kind of highlight why I think it's relevant for our discussion. So the first one really is a recent case that the commission has brought against Meta, and it was a VR acquisition of this small company within that was working on fitness kind of apps for the VR ecosystem. And the reason I bring it up is not because the theories of that case are highly applicable in AI or something, but there was a very kind of a big question that loomed over that case during litigation. And that was whether antitrust laws or competition law could even apply in such a nascent market. And in particular, there is a question that is always presented in merger cases, which is market definition. So whether the government can carry the burden of defining what the case law kind of describes as the relevant market, where basically companies compete against each other. And during that case, Meta made various arguments, including experts that were brought to trial, that this market is too nascent, there's too much entry and exit and too much fluctuation in terms of market shares to think about it as a relevant antitrust market, or to think that antitrust liability can apply in a market that only emerged a year or a year and a half ago, doesn't have a clear monetization strategy. And, the largest companies don't have more than, several tens of thousands or hundreds of thousands of users. And very helpfully, the court kind of took a step back and kind of reminded us that, the market definition exercise can apply also in nascent markets and markets where there's a lot of entry. And really the focus should be on commercial realities. So whether companies view each other as competitors, do internal documents of the companies recognize certain companies as a competitive threat? And really that focus on the core principles of how companies recognize each other, how do they talk about competitive dynamics, should really guide the courts when they think about market definition. And more broadly about competition. And really, I think the bottom line for us was that we can bring cases in nascent markets, in cases that are evolving quickly. And that is a very reassuring sign for us that we can still think about, antitrust theories, even when there is a lot of fluctuation in the markets. And even when the monetization strategy is not entirely clear to the companies that are competing within the markets. And that kind of ties back to the second point, which is really about understanding the plumbing and the infrastructure. So I think a lot of the conversation today probably revolved around this question about, what is the plumbing? What is the infrastructure for AI? Who's dominating what? What is the infrastructure? What's kind of what are the barnacles, right? Like we're trying to kind of grapple with questions of the geography kind of the ecosystem or of these markets. And I think, one thing that we learned from our big Meta Conduct case is that in some cases, companies will first kind of try to scale, try to build the flywheel, try to build the ecosystem, and only later will kind of grapple with question, okay, how are we monetizing this? Like, what is going to be the infrastructure for monetization? What would be the plumbing, right? So in the case of Meta or Facebook back then, right, there was one thing was to grow the network and kind of generate a positive flywheel around the core product. And the question came up later of, okay, so how do we now monetize this product? How do we kind of branch out and use this kind of network that we created to basically make the company profitable? So that's another thing to kind of remind ourselves, right? So it doesn't mean that there aren't concerns if all the companies in the market are losing money or haven't figured out kind of like, how are we going to monetize this platform or product, right? The real concern for us is really when markets tip, right? When the markets tip and they're kind of dominated by a number of companies and or firms. And the last point is kind of related to the infrastructure question. And this comes from our most recent merger challenge that involves Microsoft and Activision. And one of the markets that we allege in that case and is currently being litigated, so I don't know what the outcome is going to be, but I can describe our concerns, is cloud gaming. And in that market, one of our major concerns is that the future of gaming is going to kind of move towards the cloud, and kind of a Netflix version of gaming will emerge. But the second concern that we have, especially given kind of that the commission articulated, is that Microsoft is also one of the dominant actors within cloud infrastructure, on top of which this service is provided. So, without going too much into the case itself, right? There's the questions I think that we can also ask in the AI space of markets that are developed upon infrastructure, where firms both own the infrastructure and are competitors within the markets that develop on top of the infrastructure, and whether those kind of dynamics create more reason for concern.
Thank you. I mean, it strikes me that the OpenAI case, just not the complaint, but the company is an interesting example because it actually started as a not-for-profit company and does not own cloud computing services. It was licensing from Google. So in a way, it was a new market entrant, and then subsequently had a large investment from Microsoft and so forth. And I guess the question is, well, what role does competition have to play in this kind of development if we're now facing generative AI that's being developed on this kind of business model? How does it, I suppose, is competition law the right framing? I don't know whether Sarah or Shaul, you have or is it really a question of not thinking about it in those terms, but thinking about access to expertise, regulating through, corporate law structures, looking to other legal and infrastructural tools?
I can start. So it's notable that OpenAI made the shift from being nonprofit to for-profit at the juncture at which it realized if it was going to build these systems, it needed to take massive amounts of investment from Microsoft. So it's not sort of an irrelevant point that it made a shift from being not-for-profit to for-profit structure. I think it underscores that you cannot meaningfully create artificial intelligence at scale without having some sort of tie to a massive cloud infrastructure provider. Same thing, by the way, in across the startup space, in open source AI, all of these firms have contracts with existing cloud providers. Hugging Face works with Google Cloud. Anthropic, I believe, is with AWS. Like they all have to have some sort of relationship with a big tech firm in order to build AI at scale. We're now starting to see commentary from folks like Sam Altman acknowledging that this resource dependency is becoming a problem. Just in the last week, he made comments to the effect of, we need to figure out, maybe scale isn't the only way to do this. And now sort of the next evolution is going to be efficiency. That happens at the same time that Microsoft announces it's made these investments in chip infrastructure. Like there's a lot that's going on here around being able to build AI that functions at scale, that is optimized at scale, which is, again, not the only way to build AI. There are other models from which we could be turning, but this is where the industry current is overwhelmingly focused, is on this flavor of AI. And conveniently, the companies that are best placed to address, to sort of work within this AI at scale ecosystem are the big cloud firms who have, already have the data centers, who have for several years been making investments in new kinds of chips and hardware and things that will enable them to work more efficiently. But even now, for the time being, they're starting to throttle cloud access because they just cannot keep these systems up and running, given the heavy demand on compute.
Shaul or Kevin, did you want to say anything?
Yeah, and so the question was whether competition law is the right framework. Yeah, I think to Sarah's point, the point that Sarah just made, I think is very, very notable. This shift from nonprofit to for-profit for many of the AI startups that are coming forward. And I think one thing that's quite even ironic is that OpenAI was started as a nonprofit, then became a for-profit, at least temporarily, with their partnership with Microsoft. And then some AI scientists there were a bit bummed by the shift to for-profit. So they left and created Anthropic AI. And then 6 months later, Google invested $300 million in Anthropic AI, and the same type of deal came forth. So I think it is a bit of a bind because it just shows how hard it is to develop these models without these big resources. And today, the entities that can provide these resources that are the best place to provide these resources are these big tech companies. There's kind of this inevitable trend toward going to them. And a lot of these deals are actually not for cash, they're for computing resources. So when you hear that Anthropic AI got a $300 million investment from Google, most of those are in computing credits. In terms of whether competition law is the right framework, I don't know. I think it may be, and it's a hard question, but I think there are a bunch of different challenges. And going back to what Shaul mentioned in his introductory remarks, I think one thing that's very interesting is this idea of nascency, nascent industry, nascent products, and how competition law sometimes struggles with that. And I think it's going to be especially challenging with AI because AI has this interesting feature where the same model can be applied to different use cases, or the same core technology can be adapted for different use cases. Where if you think about a company like DeepMind, they started with Go, a model playing Go and a model playing video games. And the same type of models and the advances that they really achieved there then help them create AlphaFold, which is now used for drug discovery or protein research, and will help them, or has helped them already, create some products that now are monetized through, I think, healthcare diagnostic apps and things like that. So I think it's very tricky with AI because if you look at a startup today that hasn't monetized yet because they're focusing on more fundamental research, it doesn't mean that what they've built already can be monetized in a way that may compete with the big tech company that's acquiring them. But I think that's something that competition law, at least in its current framework, may be very blind to. And in a way, I think one way I've been thinking about in terms of adapting antitrust law to this new AI frontier could be to think less about product competition, but more in terms of capabilities, competition, this framing around capabilities, where it's less about, oh, today we are both building the same product, and therefore there's competition, there's substitutability of our products, so we should not merge, otherwise people will have less choice. It's more around, today we are the only 2 or 3 firms that have the capability to build AI models that could be used in a variety of ways. And if we merge, we foreclose other entities in the economy from building this capability. And there, I think there's also another concern that's much harder to predict in terms of merger review economic analysis of, if you prevent these startups from being independent, to Sarah's point, it may be more and more or less and less easy for new and more efficient methods of AI competition to develop, because the AI incumbents that would acquire them have less incentives to make things more efficient in an interesting way. Because in the status quo, they're the only one that are able to develop and maybe sometimes use these models. Whereas if we let the startups be more independent, there could be more innovation because the startups need to become more efficient. Even if you raise $300 million, the biggest models today take $20 million, I think, about to train. So yeah, but a bit more than 10 tries, and then you're out of money. So I think that there needs to be a shift in competition law doctrine if we want it to be able to address this. And just the last comment, a bit more theoretical, is the question of whether competition law is even the right tool and the right body of doctrine, because it's interesting that competition law, if we think about access to AI, competition law seems not necessarily the best tool there, because access to AI relates to access to a specific technology, whereas merger review really looks at market structure and specific firms, which does not necessarily align with guaranteeing access to a specific technology. And there, we could think it would be more a notion of maybe a separations regime, where the AI provider are separate from other business lines, so there are maybe less risk of foreclosure, and this entity prioritizing their own their own benefits in a way that's anti-competitive. And then if we have a separate entity doing AI, we could think about things like IP incentives to promote sharing what they've built with others, if they can also benefit from others' use of their own technology. And in this way, that would align a bit more with technological access rather than firm by firm type of dynamics.
Great, thank you. So maybe I'll ask Shaul to reflect and also throw the last question before we turn into the audience, which is that should the state be providing certain components as a public infrastructure? So if computing power is really, cloud computing is really the thing where the moment big tech create a bottleneck by imposing high costs or creating dependencies, should the United States be doing what some of the other countries, as Benedict had mentioned in the earlier panel, India or China, trying to create some kind of a public infrastructure on which smaller companies might be able to build and thus create less dependencies?
So yeah, I'm not going to weigh in on what's the preferable policy choice, but I will mention two things I think regarding commercial realities that are worth thinking about is the emergence of the emergence of the Googles and the Facebooks, etc. Kind of really happened in a time where we had kind of these two zeros really dominating. One was zero interest rates, and the second zero was zero marginal costs, right? So zero interest rates for cost of capital. And the second zero was basically that fixed costs were high, but the marginal costs of usage were very, very low. So when we thought about network effects in cases that we're currently litigating, for example, right, the network effects we're talking about are really about, okay, I have a social flywheel, right? I have all the users on my infrastructure, and that requires kind of interacting with my infrastructure to reach other people in my social network. There is a question, right, in this space, what are going to be the network effects moving forward, and what is kind of the infrastructure? So we need to remind ourselves that we are no longer in a zero interest rate environment, right? Costs of capital are very high. And what does that mean to kind of companies trying to emerge on the scene? And the second thing is really around this question about zero marginal cost, right? Is it still true that any additional user that is kind of joining my service and starting using it literally costs me nothing? And what does that mean if a firm can't, do that thing that was really the shtick of the 2000, like scaling overnight into kind of like a behemoth or kind of like a huge user interface? So those are kind of two questions that are really, I think, front and center when we think about commercial realities and platforms. And to the policy question, without weighing on it, I think, we have a lot of areas in the US where we have regulation and even public infrastructure and competition law kind of operating on top of each other. So, one example would be airlines, where you have the DOT and the states investing in infrastructure. You have the DOT regulating, slots and regulating kind of which carrier can fly where and how many hours, an airline pilot should train before they can fly a commercial plane, et cetera. And on top of that, we have another layer of antitrust enforcement, right? And an example of that would be, DOJ currently challenging a merger between airlines, right? So I think, we at the competition agencies will enforce the laws, even if we don't have kind of the infrastructure in place. But it doesn't mean that infrastructure investments and kind of a public utility aspect kind of precludes competition concerns and kind of the ability to apply competition law.
Great.
Can I jump
Sure,
in
of
quickly on the
course.
last point? So when in the question about just, sort of broadening access, why don't we just build more data centers? I think it's important to also foreground that these infrastructures have tremendous material costs. that they, both in terms of the energy requirements of building these systems, the groundwater supplies needed to supply them. By the way, those groundwater supplies draw often on public aquifers, often in some of the most resource-strained communities in the US and elsewhere. The Netherlands has banned the construction of new data centers for hyperscalers specifically for these reasons, because there were local organizers who said that the ancillary effects on their communities were too significant. So for that reason, I'm not convinced that access is really the question that we should be turning to here. I think we should be looking holistically at, who is benefiting from the widespread application of AI, to what uses is it being put, and are those uses working in the broad public interest? And so far, I have not seen very significant evidence to support that. And I think that that's really important, that it be foregrounded in the conversation around what policymaking or enforcement of existing law for these companies looks like.
Very important point. And with that, we'll turn to questions.
You. So I think what I wanted to say follows nicely from what Sarah said. I wanted to express some mild skepticism on this idea of access. And so I don't know. So I was looking at the title of this panel, Infrastructural Power, Competition. And so it seems like this panel is really about corporate power over AI capability, if we want to call it that way. And I guess, a question that your interventions raised in my head is, where is the corporate power actually forming? And it's, at least from what I heard from Shaul, really kind of crystallized for me the idea that AI is not this kind of fluctuating. So you could imagine AI as this fluctuating thing that's accessible to all, but it becomes entrenched and it becomes intermeshed with corporate power from the moment that you start creating some sort of proprietary infrastructural system around it. So you add, APIs, you add certain kind of friction, you add certain entry-exit access barriers and kind of differential, asymmetric ability to benefit from it, to access it, to use it. So I'm wondering if that's maybe in tension with the access idea, and also maybe questions a little bit this kind of move from infrastructure to capabilities. So maybe the problem that antitrust law and corporate law and kind of economic law needs to tackle is really this question of, when is generative AI, when does it become something that we should treat as infrastructure or as an infrastructural asset that, if controlled by a private actor, needs some specific forms of regulation, be they antitrust or other?
I'm happy to take it.
Yeah, go ahead.
So taking a step back, I would argue that the control originates from the nascency of artificial intelligence, that AI as we know it today is a product of, the sort of commercial surveillance at scale created by these companies. The creation of massive amounts of data, needing to find some way to render that data useful, and sort of like, if you look at who was doing the work back in like 2012, it's happening within these big tech firms. The sort of capture of AI as an academic field also sort of tracks with that there's been an increasing dominance of like, where are AI PhDs going? I think it's a tremendous percentage are going to work at big tech companies today. The companies have doubled their presence at the largest AI conferences, that the field is sort of converging on this like monoculture, as Karen Howe recently called it, of artificial intelligence at scale. And it's in many ways sort of like a solution to a problem of a lot of data and a lot of compute, and needing to figure out a way to make it useful in commercial products, rather than, sort of the, that it sort of existed preformed and was mainstreamed into these companies. Yeah.
Yeah, without, again, weighing on this question about the infrastructure and how kind of durable the infrastructure within a corporate form is versus kind of infrastructure, you know, writ large, because it's like plumbing question in the AI space. I think it is very helpful for us for purposes of kind of our intellectual broad discussion to really separate two things, right? One is corporate control of infrastructure and scale and efficiency. And the other is the actual efficiency that is kind of inherent within the plumbing or the infrastructure itself. So maybe I'll give an example. So you can have a factory, right? And a certain size of factory is the most efficient way to produce a product, right? And you need that scale in order to produce that product. And you can then combine 2 or 3 of those factories into one corporate kind of umbrella, but you're not actually introducing any inherent efficiencies within those factories, or you're not adding anything in terms of that corporate scale that you created, right? So I think there needs to be kind of like, when we discuss these issues, when right, you know, politicians consider regulation, et cetera, right? It's very important to make that distinction between what is inherent within the infrastructure, what is the scale that we actually need to provide the service or to create the product, versus kind of what is within the corporate umbrella and what's outside the corporate umbrella. And I think that might help us kind of in this discussion. And the second thing is just to talk about the barnacles, whether that characterization is true or not. I think there is a lot for us to learn about kind of fine tuning and what are going to be those kind of niche products or products that are developed in niche markets. And again, there's a question about kind of like whether it's within the broader corporate umbrella, whether it's like a separate corporate entity that sits and needs to utilize kind of the infrastructure of a bigger corporation. So I think all of those questions are maybe new in this space, but they're not novel or new for kind of how we think about infrastructure and competition, and have been thinking about that for more than 100 years in this country.
Great.
Thank you. Thank you for this lecture. It was wonderful. So I have a question going back to the nascency point. So we have seen how in recent years we have gone from new entrants to actors who acquire a lot of market power very quickly. And of course, your wonderful report also cites Maurice Stug as saying that now we are the product. We're not the target audience, but we are the product itself. So I was wondering whether, in your opinion, the whole Schumpeterian notion of creative destruction that has been underlying much of our foreclosure theory and has been viewed rather as a panacea is irrelevant at this point due to the entry barriers arising from infrastructure. Thank you.
Maybe I'll just say, since I work now with Maurice and he's wonderful. I get to work with all these great people, so it's awesome. But I would just say that, you know, we need to be also skeptical of those claims, right? So the first thing that companies might want to say is, you know, there's a paradigm shift, there's a new technology, no need for intervention, no, there's no problems with our markets. You know, this is something that's going to arrive on the scene and totally dislodge our position. So I think we should be, on the one hand, very careful and learn markets and see how they develop and whether they're kind of opportunities to dislodge incumbents versus kind of sloganeering. So yeah, learning the commercial realities, being very aware of what's going on in the markets and as they develop is key.
Maybe just before we go to the last question, just to make a point, because it hasn't come across, which is that in the developing countries, in the developing economies, there is active market making with these technologies, including through development institutions who believe, in a way, sloganeering maybe too strong of a term, but who see efficiencies and who see innovation in these technologies and bring them as part of market creation. So here, you know, displacing some of the existing local markets, local traditions, social practices. And so there's in a way, when we think about kind of regulation and what to do about generative AI, but also this big tech companies, that there's this whole other part where they're quite dominant. Microsoft is one of the big companies that is really very dominant in what one might call digital development. Its cloud services are used by a lot of international development institutions. And it's quite likely that, given the link between Microsoft and OpenAI, that those services are going to become part of what's being given in the developing economies. And so while we are in this part of the world talking about regulation and privacy and competition laws, there's experimentation that's taking place in other countries without much of safeguards. And I think it's important to also keep in mind, and I know we're going to run out of time, but I was going to ask Shaul to what extent kind of FTC speaks to its counterparts including in developing economies and trying to coordinate and take account of sort of more global distributive impacts of kind of legal interventions that we make in this part of the world. Sorry, I didn't mean to.
Well, first, I just want to say it was a wonderful panel. And certainly we have to be concerned about increasing concentrations of power in the digital sphere. Sarah's recent report outlines many of these risks. And I've also heard the phrase used by some of the generative AI proponents, the consolidation of knowledge. And I think we might keep that phrase in mind as to where this could be heading. But I wanted to speak specifically to the FTC's role. And I did mention earlier the complaint, and I hope you've taken a look at, and I hope you've opened the investigation. But I also want to share a little history with you, because competition policy is the wrong lens for the FTC on this issue. Google's acquisition of DoubleClick, that was a competition issue. And Facebook's acquisition of WhatsApp and Instagram, that was a competition issue. But this is fundamentally, for FTC purposes, a consumer protection issue. And it takes us into Section 5 and into the statements that the Commission has previously made about AI products and what companies that offer AI products would be expected to do. And I think you have a very clear obligation to act on the complaint you've received. But the other thing I want to tell you about the history, because I have been at this for a long time, the FTC moves very, very slowly. It took us 2 years from 2009 to 2011 to get the Google and Facebook settlements. And that was after testifying repeatedly in Congress, repeatedly petitioning the Commission, and eventually we got the settlements. But it actually took 8 years from 2011 to 2019 before the Commission brought its first enforcement action against Facebook. We had, through a Freedom of Information Act request, learned that there were 26,000 complaints pending at the FTC. There was Cambridge Analytica. There was a long litany of reasons why the FTC should not have waited 8 years for the first enforcement action. So I'm here somewhat to plead with you and to ask you to go back to the commissioners. We can't wait 10 years from the time we filed the complaint before you take your first enforcement action on generative AI.
Yeah.
So thank you for the question slash complaint. And I should have said this in advance, and I apologize that I didn't. That yes, the FTC also is thinking through the lens of consumer protection and privacy about the issues of generative AI. There was a statement made in 21, kind of really putting the market on notice with respect to discrimination and bias in the application of AI. And very recently, there was another statement put out, or another blog post put out by the Bureau of Consumer Protection talking about claims surrounding kind of AIs. But I can, it's hard for me to kind of make any statements about ongoing matters, especially since they're kind of on the consumer protection side and not the competition side. But I can assure that kind of the same way we're thinking in the Bureau of Competition about competition and antitrust aspects of these issues is also front and center on the consumer protection side.